let me take this opportunity to welcome you all to this Portfolio Committee meeting. And I want to convey special welcome to the newly appointed commissioners of the Public Service Commission. And I also want to announce to the committee that today we are having the last meeting of this term. The next meeting will be in August. Honorable members, on the 19th of August, 2021, the Speaker, through ATC number 107, introduced and referred the Public Administration Laws General Amendment Bill to the Portfolio Committee on Public Service and Administration, as well as referral to the joint tagging mechanism for classifications in terms of Joint Rule 160. The bill is sponsored by one of our own members, Dr. Leon Schreiber. Thank you, Dr. Schreiber, for drafting the bill. Honorable members, as you are aware, that the Department of Public Service and Administration, the National School of Government, and the Public Service Commission have been in the process of legislative amendments since the beginning of the 6th administration. We have invited them to be part of this meeting and participate in order to ensure we don't duplicate their amendments, as we are in the process of considering the bill by Dr. Schreiber. We further invited the Presidency Social Economic Impact Assessment Unit to provide an input on this bill. With those few words, allow me to invite Dr. Schreiber to officially introduce the bill to the committee and later allow the department to present. But before Dr. Schreiber can take the platform, let me first of all find out if we have any apologies for today's meeting. Can Mastole indicate if we have apologies?
Good morning, Chair, and good morning to honorable members and the commissioners in the meeting and colleagues. Yes, Chairperson, we only have one apology from Honorable Motsepe, as indicated that she's still not feeling well. That's the only apology in terms of the committee members, Chair. Thank you so much.
Thank you, Mastole. I now invite Dr. Schreiber to take the platform. Thank you.
Good morning, Chairperson, and good morning, colleagues, and also to the officials. It is a privilege for me to be on the other side of the fence today, Chairperson, as a presenter, instead of the one asking questions. So thank you very much for everyone who has joined in this meeting. Chair, if I may, I'm just going to share my screen here. So let me check if everything works. Okay, can you see the presentation in the background, Chair?
Yes, I can see it.
Okay, thanks very much, Chair. Okay, let's jump right into it, colleagues, with a bit of context and background on this. So the Public Administration Laws General Amendment Bill, the original memorandum was out in a call for comments. I can confirm that 122 comments were received and processed with unanimous support from people who commented on this bill. And then also just to inform the committee about this letter that was submitted to NEDLAC on the 20th of April 2021, which also introduced and shared the bill with them as part of the regular process. No need to read through it. I'm just bringing it to the committee's attention. No response was received from NEDLAC in this regard, but this letter was shared with them. Chair, let me make full screen here. Great. So in terms of the context, Chairperson, a couple of extracts from relevant documents, just to set the scene here. The first one being one of the first recommendations from the State Capture Commission report, which this is from the first volume, recommendations 418 and 419. We've heard from the speaker yesterday about a legal opinion that has confirmed Parliament's right to engage with these recommendations and not having to wait for anything else to happen first. So what is clear from this recommendation, Chair, and of course we are still waiting for the final report or the final volume to come out, but it's very clear here that the Commission says that appointments, and this is now specifically related to state-owned enterprises, can no longer be left solely in the hands of politicians, because in the main they failed dismally to give SOE members of boards, CEOs, CFOs, they failed to appoint people with integrity and who have what it will take to lead these institutions successfully. They are all going down one by one quite often, and they depend on bailouts. So very clearly an indication in the first volume that the appointment process is really a critical area that needs to be reformed going forward in order to tackle state capture, but as I will show, also to improve state capacity and service delivery. Then, Chair, I move on to the next slide. A couple of extracts from this committee's own work. As the colleagues will know, many of the issues canvassed in this bill are not new, and one of the more recent ones comes from a report from this committee on the 16th of March, and I just referenced the underlined part there, which says that recruitment processes in the public service need to be reviewed and strengthened in order to ensure capable and competent personnel are appointed based on merits. Another one from 6th of May 2022, which refers to the independence of the Public Service Commission, another area that's tackled by this bill, and says, recommends that appointment of the PSC Director General through the Public Service Act and participation in the FOSAD structure compromise the independence of the Commission. So that's a clear view taken by the committee. And then also finally, another such recommendation, which clearly makes this case for the independence and the importance of markers of constitutional independence also as contained in the Kader Asmal recommendations regarding the Public Service Commission. So, Chair, the context here is quickly canvassed to show that indeed the letter and the spirit of this bill is not only entirely consistent with recommendations made by the State Capture Commission, but also with recommendations repeatedly made by this very portfolio committee. So it's not something that just dropped from the sky. It's something that has been grappled with and on our agenda for quite a while. And I think beyond, just flagging problems and making recommendations, it's time to put action on the table. So that is what the Public Administration Law's General Amendment Bill seeks to do. In the first instance, it seeks to prohibit political office bearers, that's politicians, from employment in the public service. It secondly seeks to prohibit a special service benefit for DGs or HODs who have been dismissed, so not retired, but dismissed from public service. It thirdly seeks to enhance the financial independence of the Public Service Commission, as well as relatedly, the administrative independence of the Public Service Commission. In the fifth case, it seeks to mandate the Public Service Commission to enforce merit-based appointments free from political interference. And finally, it seeks to empower the Public Service Commission to take remedial action, and this obviously relates to the many recommendations from the PSC which often are not implemented. Chair, I will now take us through each of these six core pillars of the bill. The first one on prohibiting political office bearers from public service employment. It's worth emphasizing very strongly here that this exact provision, word for word, was adopted a few weeks ago in the National Assembly in the form of the Municipal Systems Amendment Bill. So this exact clause is already now on the President's desk, and should he sign that bill, it will prevent in the municipal sphere political office holders from working in the administration. Now, Chair, logic would dictate that we cannot single out only the municipal sphere. The problem that has been identified in terms of the politicization of the civil service certainly does not end at the municipal or local level, and it's therefore only logical that this same provision must be extended to national and provincial government departments. I think it's not only rational and from a policy point of view, but also from a legal point of view, that there cannot be this discrepancy between what applies to municipal workers and what applies in other spheres. And therefore, this, as I say, this wording comes exactly from that recently passed amendment. And it makes it clear that an employee of the public service may not hold political office in a political party or political organizations, whether in a permanent, temporary, or acting capacity. And then it has provisions for transition. So when a person is an employee, when Section 1 becomes operational and currently holds political office, they have 1 year to comply with that section by resigning from political office before they can accept a promotion, transfer, or secondment. And again, making it clear that political rights are not limited beyond this provision. Once again, Chair, word for word from the Municipal Systems Amendment Bill, which was very strongly supported in the National Assembly by all political parties. Then on to the second provision, which also is a matter of profound logic and rationality. At the moment, unfortunately, the Public Service Act leaves the door open for officials who have been dismissed, in other words, with cause, from the public service to still receive a special service benefit. Chair, I would hope it goes without saying that the idea of providing a special benefit, an additional payment, some kind of bonus to someone who has been dismissed from the public service is entirely illogical, because if they deserved such a benefit, they would not have been dismissed in the first instance. So what this second amendment or step does is to simply remove the provision for dismissal to be a ground for a special service benefit. So a DG or HOD who retires and has nothing against them, no dismissal, will remain eligible, of course, but it is to prevent the unjustified enrichment of people who have been dismissed from public service. On to the third point regarding the financial independence of the Public Service Commission. Chair, this is an important one because as the ASMAL report there and as this committee made clear, there are certain markers of independence that are very, very important, and financial independence is one of them. This committee has clearly expressed itself in the past on the problem with the Public Service Commission being reliant on government departments, not only for its budget vote, but in this case, really at the root of the problem is the fact that the Commission is not recognized as a constitutional institution in terms of the Public Finance Management Act. It's a real anomaly in this regard because you'll find everything else there. I think 11 other institutions, the Public Protector, ICASA, other institutions are given this important, as the committee has said, marker of independence and financial independence in the PFMA. And this amendment proposes to add the Public Service Commission into its rightful place in Schedule 1 of the Public Finance Management Act to ensure that it is also fully recognized as a constitutional institution, which means that its purpose for existence is not rooted in legislation like the Public Service Act or even the Public Service Commission Act, but it is rooted financially also in the Constitution, and that it's therefore entitled to that kind of financial independence and the ability to oversee its own financial affairs. The important thing to point out here is that in the process of investigating this amendment, we found out, and Parliament's legal advisors have also confirmed this, that there was an error made, and this is quite a serious error, in previous amendments to Schedule 1. The National Treasury confirmed that the recognition of the Commission on Remuneration of Public Office Bearers was not done through the correct process. It was simply gazetted by the department, and it was actually not done as we're trying to do here through a formal legal amendment. So, Chair, in the interest of fixing that error and preventing any kind of legal consequences or what else, this amendment would actually fix that mistake and ensure that those entities that were incorrectly gazetted are also included among the constitutional institutions. So that would apply to both the Public Service Commission and fixing the status of those other institutions. And of course, related, the fourth point is not only about financial independence, it is also about administrative independence if the Public Service Commission is to really assume the role that the Constitution envisages of having this power of oversight over the public service. So this amendment also has been much discussed in the committee and is something that I think most of us can agree on, that the Office of the Public Service Commission should be removed from the purview of the Public Service and Administration Department. It does not make sense that the institution, a constitutional institution that's supposed to exercise oversight, is nestled within a government department itself. It will do this by making the chairperson of the Public Service Commission the executive authority, whereas it's currently not clearly designated. And by removing the Office of the Public Service Commission, it will no longer be headed by a Director General, but by a fully fledged CEO who will report to the chairperson of the PSC rather than to the Minister of Public Service and Administration, as is currently the case. It also confers the relevant powers on the chairperson, importantly, after consultation with the rest of the Commission, to organize and structure the Office of the Public Service Commission, and clearly makes the CEO responsible for financial, administrative, and clerical functions. The point here is to improve accountability within the Public Service Commission, because even as we try to expand the powers of the PSC to ensure merit-based appointments, we must make sure that the PSC itself is held accountable and operates optimally. And that's what this amendment seeks to do by giving it power over its own affairs and making it really practically independent from the executive. Then getting to another important provision here, Chair, to mandate the Public Service Commission to enforce merit-based appointments. So a lot of the legislation around the PSC currently speaks about recommendations and other, if I may call it, softer provisions. But the Constitution explicitly provides that the Public Service Commission may issue directions. And it's an important distinction because a direction is something that is binding and enforceable. And specifically, if we look at section 1973 of the Constitution, it reads that no employee of the public service may be favored or prejudiced only because that person supports a particular political party or cause. And it is clear that the Public Service Commission is the institution that should be enforcing this requirement and not politicians, as the State Capture Commission has made clear. There's a clear conflict of interest when politicians have this power. So the proposal is to insert into the Public Service Commission Act the mandate for the PSC to issue directions to ensure that decisions related to recruitment, transfer, and promotion is based on ability demonstrated by proficiency, including training or other qualification, and skill that is required for the relevant area in which the recruitment, transfer, or promotion is being done, and to ensure that objectivity and fairness, so that any recruitment, transfer, or promotion is done on merit alone and does not favor or prejudice any person because that person supports or does not support a particular political party or cause. You can see the wording comes directly from the constitutional provision 1973, which is currently lacking from our legislation. So it is very, very important that we implement that provision that has been in our constitution for a long time, but in many cases has not been honored. Continuing on this mandate of the PSC to enforce merit-based appointments, to ensure that this provision is implemented, the Public Service Commission has the mandate to ensure that employment and personnel management practices are based on objectivity and fairness, include a prohibition on any recruitment, transfer, promotion, or dismissal being effected based on, in part or in whole, a particular person's support of or opposition to a particular political party or cause. This very clearly then in our law would embed the idea that cadre deployment is not allowed, that people who are loyal to particular political causes or parties do not in any way become advantaged above people who are not. And very importantly, to give real teeth to this provision, any person who fails to comply with the direction issued by the Public Service Commission under this section shall be guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 12 months or to both such fine and imprisonment. This provision also exists, and this response, this sentence, if you want to call it that, was taken from the recent amendments to the Auditor General legislation, and it makes it very clear that this is how we enforce compliance with the PSC's directives for merit-based appointments rather than political interference. Then the sixth point, Chair, is to, of course, ensure that the PSC is able to take remedial action, again, using the example of recent amendments to the Auditor General's legislation. So what it does is it inserts another section to the Public Service Commission Act to ensure that measures, directions, and recommendations issued by the PSC become legally binding. I think the last figure was 80% of recommendations by the Public Service Commission were not implemented within a one-year period. And so that clearly demonstrates the need for this amendment. Now, with this amendment, within 60 days, the relevant authority that's been given a direction or a recommendation must report to the Public Service Commission on whether that has been implemented. And if there's a failure to implement within those 60 days, the Public Service Commission is then able to investigate, summon people for in-person appearances, and report any must report failures to the provincial and national legislature, and also then clearly gets the power, the mandate, even the instruction to refer irregularities to the Auditor General, the SIU, or another similar body. Again, the point here being to give real teeth to the Public Service Commission and to ensure that there are real consequences where it finds that merit-based appointments, but also any other HR practice or the kind of problems that this committee is well aware of, is actually corrected and actually implemented. Chairperson, as I said, this bill is really a comprehensive effort to address the problems that this committee is well aware of. It seeks to depoliticize, remove the influence of politics in our public administration, and it does so across the board. And that's why I would like to make a call on members of this committee, but also really on every South African, that this is not a political or a party issue. This should be something which applies across the board, whether it is party A or B or C who is in power. None of them should have the ability to actually capture the administration and make appointments based on political considerations rather than merit. Chairperson, we are in a democracy, and at some point, every political party will find itself in opposition, some will find itself in government, and that's how democracies operate through competition. And surely every member of this committee can understand if the opposition comes to power, then they would want the same rules to apply in order to ensure that the state is not captured and subverted for political ends, as the State Capture Commission has made clear ever again. So it's a plea for non-partisanship, it's a plea for constructive inputs on this bill, but I do think, Chair, this would take us a very, very long way towards depoliticizing the civil service, towards building a capable state, and making sure no matter which party is in government, that we have a state that's able to actually execute on the policies and undertakings made by the government of the day. Thank you very much, Chair.
Thank you. I now want to welcome the Minister. I must also indicate to members that today we are not going to finalize discussions on this bill by Dr. Schreiber, but in the coming meeting, we shall engage with this properly. Can I invite the Deputy Minister, please?
Thank you, Chairperson. Let me just acknowledge you, Chairperson, members of the committee, officials that are on the platform, and just members of the public. And I want to, Chairperson, just welcome the briefing on the private members bill by the member of the Democratic Alliance, Dr. L.A. Schreiber, and to say that from our side, we just want to leave it to the committee for deliberations. Chair, I don't know whether you want me to proceed to actually introduce the business that we are here for today, or maybe just hand over to you, back to you again.
Yes, DM, I want you to, as I said, today we are not going to engage on what Dr. Schreiber has presented. We will engage with this in the next meeting. So the opportunity I'm giving you now is to present what you have come to do in the portfolio committee today.
All right. Thank you very much, Chairperson. Today we will actually be presenting to you the Public Service Amendment Bill. And to say that the bill considers public administration holistically, looking at high performance in public service that meets the basic needs of South Africans, maximizing the use of finance resources of the country, creating a people-oriented, cohesive, synergized, efficient, and effective public service. The bill also takes into consideration what is currently mooted as the future of work. The bill strengthens public service functions.
Sorry, DM, sorry. I made a mistake here. I should not have given you a Dpsa first. You will follow. Oh. I should have invited the DM in the presidency.
All right, Chairperson, I'll hand over back to you. Thank you.
Okay, then you will follow after the DM presidency. Can I invite the presidency?
Good morning, Chair, and greetings to honorable members and Deputy Minister and colleagues. We're going to present on the impact assessment that was conducted on the bill. Let me share. Okay, Chair, are you able to see the presentation? Okay, the presentation covers introduction and background on the socio-economic impact assessment system, the rationale of the private member bill that has been presented by Dr. Schreiber, the government policy focus and current initiatives, and the overall assessment of the proposed bill, as well as a recommendation. As a quick background, the socio-economic impact assessment system is an ex-ante policy analysis tool that is aimed to strengthen policy making, and it also supports decision making in terms of to regulate or not, and to or to choose different pathways so that we address the challenges that we are confronted with. And it's a system that has to be applied throughout policy and lawmaking. So it shouldn't come at the end when a policy or a bill is being finalized. It's a system that was introduced by a cabinet in 2015 to replace the regulatory impact assessment that was piloted for 2 years. So through SEIAS, departments are able to analyze broader socioeconomic challenges, associated costs and risks, and come up with mitigation actions to deal with potential unintended consequences of our policies, but also in the main to say how responsive are our policies and bills to the National Development Plan, and how is it going to improve for transformation and inclusive economic growth. And our role in the presidency within the policy and research services is to conduct independent analysis based on the proposals and SEIAS reports that are coming from departments, and also do quality assurance. With regard to the Public Administration Laws General Amendment Bill that has been introduced by Dr. Schreiber, the key aspects of the bill seeks to address or amend the 3 legislation, which is the Public Service Act, the Public Service Commission Act, the Public Administration Management Act, in order to strengthen the independence of the Public Service Commission by delisting it from Schedule 1 of the Public Service Act and to list it as Schedule 1 of the Public Finance Management Act, thus removing the Commission from the ambit of the Public Service Act. And also to assert the power of the Commission to enforce its directions towards compliance of the values and the principles as enshrined in the Constitution. And it also makes provision for the impossibility of special service benefits for HODs who are being dismissed from the public service. And also it intends to depoliticize the public service where state officials are not supposed to hold political positions in a party, organization, or structure. Chair, we need to also acknowledge that the current administration has placed building a capable, ethical, and developmental state as a top priority amongst the 7 priorities that we have to advance delivery of quality services to our citizens. So government undertook a comprehensive approach to address the capacity of the state in line with the National Development Plan and its reviews. So these are some of the interventions that government is focusing on to put effort in stabilizing the political administrative interface, to ensure that senior appointments are based on meritocracy, including also those of the local government sphere, and to capacitate the public service that we have skilled public servants who are also absorbed in the right jobs. The other important policy focus is to improve digital transformation so that we enhance the delivery of services. Another important policy focus is addressing the governance of SOEs, and there is some work that is being done to come up with an SOE legislation. And mechanisms have been also put in place to cap fraud and corruption and dealing with those who are found to have compromised the law. And it's also about ensuring that we don't only focus on individual performance within departments, but in a very integrated manner through the district delivery model, so that we are able to ensure that we deliver services in an integrated manner, and also implementation of the national priorities to happen within this model. Other initiatives by government includes the designation of our current DG in the presidency, who is now the head of the public administration, as indicated in the National Development Plan. And this is a main step towards building a professional and capable public service. There is also work around finalizing the framework for the professionalization of public service. To ensure that it's not about having qualifications and skills, but how do we also instill respect, courtesy, and integrity in dealing with the public, but also with other public servants. There is also work around conducting lifestyle audits and the process on SOE reforms to restore the governance, strengthening the law enforcement institution like the NPA and others to, and putting also mechanisms to fight fraud and corruption, and to continue to capacitate public servants and also at senior level so that they're able to contribute or improve the performance of their institutions. And there is a current work that started some years ago to amend the Public Service Act, the PAMA, and to repeal the Public Service Commission so that it provides an enabling environment for implementation of these initiatives, and also appreciating the work that has been done by Parliament by passing the Municipal Systems Amendment Bill, which is now with the President to be assented into law. So with regard to the impact assessment of the bill, I must indicate that it does cohere with some of the work that is being implemented by government. The concern was that also the basis of the bill was on the testimony given at the Commission of Inquiry on allegations of state capture since 2018, and not on recently released reports that were handed over by the President. And Dr. Schreiber has actually updated this area that is based also on the reports that are being provided to the President. And we are mindful also that the President committed to submit a full report and the implementation plan that is based on the recommendations that are coming from the Commission to Parliament. So the bill, however, does not holistically address the priority of building a capable, ethical, and developmental state. And it also parallels other important legislative amendment, the work that is being done by Department of Public Service and Administration, as well as the Public Service Commission. So it's actually addressing, or the approach it's kind of limited or narrow in addressing this important priority of government. With regard to the independence and impartiality of PSC, the bill assumes that the independence and impartiality of PSC are being compromised, hence the change of its form. The NDP also recommended that the Public Service Commission should be repurposed and repositioned to assert the standing as custodian of meritocracy in the public service. So the proposed amendments on its institutional setup in the bill are made outside a supportive business case that is informed by the views of affected staff and labor unions. So it's not about changing the form in terms of the law, but we need to consider that there are people involved. There's a need also for a change process so that people are being taken through the process. So it's a very important aspect when you change the institutional arrangements we have to engage people. So it's not about changing also the form of the institution, but also systems, processes, and organizational culture, that this is now a new way of doing things, and it has to be a very consultative process. And it is also not clear on how the proposed institutional arrangements will contribute towards the independence. So it also talks to the importance of having a business case. The modality for funding also has to be part of the business case so that it assets the independence of the Public Service Commission. So the bill appears to be a duplication to existing legislation regarding holding the executive accountable. On special service benefits, the bill assumes moral authority and seeks to correct the challenge of rewarding unethical behavior, which led to dismissal. And adding this clause into the legislation may serve as a deterrent for those who engage in unethical conduct. With regard to depoliticization of the public service, the public service regulations of 2016 approach is not to criminalize those with political ambitions, but in the main, to protect the integrity of public service in serving the public in an unbiased and impartial manner. So the focus of the bill is largely on the independent bureaucracy rather than investing in professional public service, which government is attending through the framework on professionalization of public service. So the bill is not entirely addressing the political administrative related challenges. On the depoliticization of the public service as we continue, government interventions emphasize that the public service should be insulated from political interference, influence, or manipulation, of which the role of Public Service Commission becomes important. Appointments are to be based on meritocratic criteria that includes qualifications, experience, expertise, integrity, and values, and not on political patronage. So it's not about qualifications, expertise, and experience, but also the important part is on integrity and the values. And therefore, we need to also consider soft issues that will support the legislation that is being initiated by government. Some of the soft issues include continuous training to both political and administrative leadership on the clear separation of the executive and administrative responsibility. We need to instill the philosophy of Ubuntu, but also in the main, how do we build mutual trust between the political and administrative leadership so that they are able to work together towards the performance of government, but also the respect of the supremacy of the Constitution of the Republic. So we shouldn't also assume that there's always a mischief from political heads, but we need to also learn from best practices. There are examples where you have ministers who worked well with accounting officers, and we need to have a way of capturing those best practices and issues of mutual trust, issues of understanding roles and responsibilities, issues of emotional intelligence. So those are the soft issues that needs to go into continuous trainings and also learning from other institutions on how they managed the political and administrative interface. So in conclusion, Chair and honorable members, the bill is based on the work that is done by the Zondo Commission, and we have updated this in terms of what Dr. Schreiber spoke about with regard to the reports that are coming through. the proposed institutional arrangements of PSC are not supported by a business case in the case of this private member bill, and the clarity on a modality of its funding. So this element might result in terms of pushback or uncertainty with regard to the affected staff. And the bill has a limited approach in dealing with the entire priority of building a capable, ethical, and developmental state. So our recommendation is that, Chair, that government be allowed to continue with its policy focus and initiatives and to expedite the finalization of this key legislation, the Public Service Act, the PAMA, and the repeal of the Public Service Act, and implementation of the Municipal Systems Amendment Bill. The finalization of the framework for professionalization of public service is also a very key framework that needs to be finalized and be implemented accordingly. So that's basically the presentation. Thank you very much, Chair and honorable members.
Thank you. I will now allow honorable members to ask questions if they have. Can I see hands? Honorable Ntuli, come in. Honorable Kondwe, Honorable Schreiber, thereafter.
Chair, greetings, Chair, and the meeting. And Chair, can I request that I switch my video off? I've got the problem of the internet with me here. Chairperson.
Hey, from a meeting.
Chairperson, thank you very much.
You can switch off your video, Honorable Ntuli.
Thank you, Chair. Chairperson, I would love to thank the presenters. Firstly, Mr. Honorable Schreiber, and also the department, the presidency. And one would love to recommend the good work that is in pipeline insofar as the three legislations are concerned, and that indeed these legislations are taking the posture of the deliberations of the portfolio committee meetings from time to time. Now we are then looking forward. We are then looking forward to these three legislation, and also one would love to commend Honorable Schreiber to take his time in this regard, bearing in mind that we are not going to deliberate on the issues today, but the issues are set for future. And thank you very much, Chairperson.
Honorable Kondwe.
Chairperson, let me also start by appreciating the presentations, more especially the presentation by Honorable Schreiber. This is a bold bill that will ensure that the separation between the state and the political realm is firmly entrenched especially when it comes to our public service. I know we're not deliberating on it, so I will not say any more around the bill, but I do have questions for the presidency around the socio-economic impact assessment that they did in relation to PALGAP. PALGAP is the bill that Honorable Schreiber has just presented before the committee. In slide 5, they state that the current government has undertaken a comprehensive approach to addressing the capacity of the state in line with the NDP. And I'm surprised that the presidency can make such an assertion when very recently our government admitted that we would not be able to achieve some of the goals and the targets in the NDP, given so much that has happened, the slow growth in our economy, and also, the spate of corruption and malfeasance right across government. And so I take the view that, one of the goals that we'll not be able to achieve is the goal of ensuring that we build a capable and ethical state, public service, given the problems that we're currently experiencing in our public service. And truly speaking, Chair, it's 11 years into the NDP, and to make reference to the NDP at this stage, when our very government has admitted that we're not going to be able to make goals, the goals contained in the NDP, I just find it very puzzling that they can indicate that our government has taken a comprehensive approach to addressing the capacity of the state in line with the NDP. And there's no denying that government has introduced a number of initiatives in the public service aimed at promoting and capability and ethics, such as the framework for the professionalization of the public service and the introduction of compulsory lifestyle audits for public servants. However, all these initiatives are not bearing fruit. When is this framework coming into effect? And there's been so much talk, it's been touted as if it's the panacea to all the problems that we're experiencing in the public service. But when is it coming into effect? I mean, and the lifestyle audits, you and I know, Chairperson, that the pace at which they are being implemented is very slow. We've got departments that haven't even started implementing those lifestyle audits. And so for them to indicate that there are already initiatives that have been introduced that can address some of the issues raised in the bill, I just think that they're being a bit disingenuous in this sense, because these initiatives, some of these initiatives are really not bearing fruits. And then they point to the fact that the NSG has all these training programs on offer that can address some of the issues. But the NSG has admitted themselves that most of the time when they have a post-evaluation post-evaluation, they require public servants to evaluate courses after the fact. Most of the public servants say that they are unable to implement some of the things that they've learned in those courses. And so there has to be a connect between what the courses that the NSG has on offer and what the challenges that we're facing in the public service. And currently there isn't such a connect. In fact, there's a disconnect, if I have to be frank about it. And in slide 6, the presidency states that the basis of the bill is the testimony given during the Zondo Commission, and that is not the basis of the bill. In making reference to the testimony and some of the observations made during the Zondo Commission, I believe Honorable Schreiber was just giving context to the conceptualization of the bill as a whole. And then in slide 7, they state that PALGAP does not holistically address the priority of building a capable and ethical state. I would like them to explain what they mean by this statement, because the bill does touch extensively on the recruitment of persons on the basis of merit and on the basis of their skills and competence. And this forms the very basis of building a capable, ethical, and developmental public service. And I want to find out whether they feel that other bills, such as the Palmer Act, holistically address this priority, because it baffles me that they think that this bill does not holistically address the priority of building a capable, ethical state, and the Palmer Act does. So I want to find out how their reasoning in that regard. And then slide 8. And they provide that the bill assumes that the independence and impartiality of the PSC are compromised. Does the PSC not make this very assumption, hence them proposing the PSC bill, which seeks to establish a secretariat to ensure the independence and impartiality of the Public Service Commission? So in other words, Chairperson, what I'm trying to say is that the PSC has admitted themselves that, they feel that they require more independence and impartiality, hence them introducing this bill that will ensure that they have a secretariat. And the PSC has itself indicated that it desires greater independence and impartiality. Therefore, would it have not been better for them to state that the bill will add more value or augment the PSC bill, because it reinforces the PSC bill, in my view. And then slide 8 again provides that the NDP recommended that the PSC be repurposed and repositioned to assert its standing as the custodian of meritocracy in the public service. As I indicated earlier on in my opening, we're 11 years into the NDP, and to state that the PSC has not been repurposed or repositioned, and 11 years down the line, why has it not happened? And PELGAPS, wants to assist in repositioning and repurposing, the PSC in this regard. And then slide 9, they state that the bill does not address the political and administrative interface. I just need them to explain what they mean by this, because the bill seeks to address exactly this in prohibiting political office bearers from holding employment in the public service. I thank you, Chairperson.
Honorable Mkweba.
Thank you very much, Chair. Chair, can I close my video? I've got a network problem.
All right.
No, thanks. Thank you very much, Chair, and good morning to the DM, Honorable Chana, and honorable members, the team from the Presidency, and also the team from the Dpsa, and also the acting chair of the Public Service Commission. Chair, one, let me appreciate the two presentations, one from Honorable Schreiber and the Presidents. Chair, in fact, from the presentation of, which is the private member bill of Honorable Schreiber, I don't have initially questions, but rather want to highlight what the bill does not take into account, Chair. For example, Chair, the NDP, if you read it, stipulates that there is a need to stabilize the political administrative interface, especially in the public service. And obvious, it also speaks on how we must then recruit in the public service to avoid political connections, but rather look at the skills and expertise. Chair, but now the bill assumes that there are no clear lines of appointment in the public service, and it does not take into account work that is being undertaken by the public service, particularly the amendment of PAMA that have been also in the presentation from the Presidents touched it, and also the PSA amendment bill and the professionalization framework headed by the National School of Government, and the introduction of the lifestyle audits, because those are the presentations that were presented in this before this portfolio committee. And also, Chair, I think it's important that we must note the work done by our government, taking decisive measures to deal with maladministration and prevention of corruption in the public service. Thus, the amendment of the PSA Amendment Bill in prohibiting the heads of departments from holding political office. So, Chair, again, the role of the Public Service Commission, it's clear, is to champion the norms and standards and monitoring the recruitment process. And obvious, Chair, the powers of the Public Service Commission are set out in Chapter 10 of the Constitution. That gives its independence. That comes from reporting to Parliament. It's a known thing that the Public Service Commission reports to Parliament. And therefore...
Can I come in, honorable members? Remember, I said the presentation by Honorable Schreiber is not going to be debated today.
No, I understand that, Chair, but I thought that I must clarify some of the issues. That is important for the people of South Africa, so that it must not be seen as we have a government that is not doing things, or government that is not implementing, some of these issues, Chair. I think it's important that at least we must then be able to clarify some of the issues. I understand what you have said in your opening remarks, but it's important that, Chair, also give the people of South Africa the understanding in terms of this issue.
Chairperson, on a point of order.
Point of order, Honorable McGraw.
Yeah, I would agree that we stay to your ruling, Chair, because it's going to tempt other members to also now, have an input on the issue.
Yeah, I said this presentation by Honorable Schreiber must not be debated today. It will be debated in the next meeting. I stick to that, and I appeal to all other members to honor that ruling.
No, thank you very much, Chair. But okay, let me move from the presentation of Honorable Schreiber. But at least, Chair, we must always debate issues with facts. Then, Chair, one appreciate the progress report from the presidents, but I've got only one question, Chair. I understand that the president will be submitting the full report and the implementation plan to Parliament in terms of the state capture report. My question then to the presidents, what should be then the best way, or should Parliament wait for the formal tabling of the state capture report by the president in order to develop or strengthen the existing legislation, Chair? I thank you very much, Chairperson.
Honorable Komani.
Thank you very much, Chairperson. And can I be allowed to maybe switch off my video if my challenges of the network persists? So thank you very much for the presentations and from both the presidency and Honorable Schreiber. And safe to say, Chair, I commend you for upholding the decision of us not debating that the presentation by Honorable Schreiber. Be it as it may, Chair, on slide 5, where the presenter spoke of the comprehensive approach towards the NDP, one would then ask, Uti, what informs the comment? Because we have such high rate of unemployment and corruption. We're not going to make, and the department has also indicated to the committee that we are not going to achieve, we are not going to be able to achieve the goals as anticipated. Then one would as well ask this question, Uguti, does the government have the capacity to realize the goals as they said them before in the previous years? And Chair, the next question would then, what would be the view about the framework of to professionalize the public service? Will the framework guard against the departments and the state institutions on appointing incompetent people in senior management positions? And Chair, the other question would then be, would public administration laws general amendment bill complement the existing legislative framework act to strengthen the loopholes in the public service? And the other one, Chair, is that on slide 7, there was a mention that the bill parallels other important legislative amendment bills, such as the Public Service Act and Public Administration Management Bill. So one would then need clarity on that. What do they mean when they say they work, they parallel the other legislative amendment bills? And then, Chair, one would finally ask that on slide 7, the department made mention of that the bill. No, not that one. Yes, that one I have raised. Do we then say what is this that should the committee wait for the tabling of the amendment bill by the Department of Public Service and Administration and Public Service Commission, which include the adoption of the framework of professionalizing the public service in order to assess whether there are no duplications, or take some of the proposals in the new proposed bill to the existing legislations? Thank you very much, Chair.
Honorable Mbele.
Thank you very much, Chairperson, and good morning to everyone on the platform and watching online. Also, let me echo my gratitude and positive impression to Honorable Schreiber for his initiative. I think it's much needed, and as was mentioned in the Parliament's budget vote yesterday, it's the kind of proactive efforts that members of Parliament should be making more often to contribute to improving the policy and the legislative landscape in this country, in collaboration with the executive, so we can dovetail all thoughts and efforts. Chairperson, my question is really rooted in one particular point from the Presidency presentation, and it was triggered by the mention by Honorable Gondwe, highlighting the admission that was made to this committee a few weeks ago that we would not, in fact, be meeting many, if not most, of our NDP goals by 2030 due to capacity constraints and just some general challenges that have stemmed from the maladministration, mismanagement, state capture, etc., etc. So there was the point in slide 6 in the PowerPoint from the Presidency that the government is working on a process of reforms of SOEs. And what that made me think of was an announcement, actually 2 announcements amongst others, by the President in his SONA address this year, where I'll just quote them very quickly. The first was the President said that Transnet will be asking for proposals from private partners for the Durban and Ngqura container terminals. And apparently those partnerships are going to be in place by October this year. So we're watching whether or not that'll come to fruition. And then shortly after that, there was the announcement that Transnet is starting a process of providing third-party access to the freight rail network. And what that makes me want to ask, because it links to the notion of reform and capacitation and improvements of the performance of SOEs, is whether the presidency could clarify or confirm whether this efforts of improving and capacitating and reorienting SOEs is rooted in and has as its spearhead thrusts the pursuit and maximization of strategic public-private partnerships, public-private collaboration, so we can turn around the SOEs and we can start seeing some innovation in the public sector and its entities. Because we know that capacity is low and likely declining. Resources certainly are declining. We know that many of our entities and SOEs are vulnerable to skills drain because the private sector often can outcompete them on salaries. So if we can just get a sort of clear confirmation or clarification about the centrality of public-private partnerships and collaboration for SOE turnaround and public sector innovation and improvements, in line with that stated objective that government is in the process on reforms of SOEs to restore governance and to improve performance. Thank you, Chair.
Honorable Ntuli and then Honorable Schreiber thereafter.
No, Chairperson. When I raised my hands that time, I wanted to sort of assist you with what Honorable Maglua raised, to say, starting from Honorable Gondwe, they were already discussing the matter. That's why my hand was up that time, Chairperson. I wanted to assist you. Thank you.
Dr. Schreiber.
Thank you, Chairperson. Just a few questions on the presentation, and thanks very much indeed to the Presidency for being part of this process. I think that there is some use in this presentation. We see the coherence and certain references like that. But I think the main question I'd like to ask is why the socio-economic impact assessment didn't include the thing that I was looking forward to the most, which is an assessment of what it was likely to mean socioeconomically if we are able to enforce merit-based appointments in the public sector. So I think that that's something that's lacking. I'd like to get a comment from the unit in terms of what would our prospects be as a country, socioeconomically speaking, if we are able to improve the appointment process so that we appoint capable and merit-based officials who then end up with a capable state. So just to check if there was any investigation into that. Also, Chair, in terms of the basis, I think the unit has responded to the Zondo reports, but really the basis is 1973 of the Constitution. I have a quick question also on the comment about the bill. In one sense, there's an argument that there's a duplication. In another sense, there's a statement about the bill cohering with some of those reforms. The question then would be whether the unit doesn't believe that there is a comprehensive package of reforms when you look at this bill in conjunction with some of the others. So these things are not in competition necessarily, but that this bill specifically addresses the appointment element, while there are other bills that are addressing things like training and the other things mentioned, whether the unit has a view on that and whether that's not the correct way to view this proposal, but also the whole package of reforms. And finally, Chair, just to say that in that vein, I don't think that there's any suggestion, and certainly want to clarify, of trying to prevent government from continuing with its own initiatives, as the bill says. In fact, I think there's a strong complementarity here. It's just that the appointment issue, recruitment, merit-based appointment, is something that's not canvassed in other legislation. And so whether the unit has a view on whether there's a complementarity there. Thank you very much.
Thank you. Can I get a response? But I want to caution again. I said what you have presented, Dr. Schreiber, is not going to be debated today. It will be debated in the following meeting. And I want to stick to that ruling. Can I get a response from Presidency? But you must not be tempted to get into discussions about the presentation that Honorable Schreiber made.
Okay, thank you, Chair, and honorable members for the questions that have been raised for clarity. With regard to the recommendations from the National Planning Commission on the achievement of the NDP, it's a very important information and early warning in terms of the implementation of the NDP. And it also shows the independence of the National Planning Commission to provide early warning to the administration, to provide honest reflection of the implementation of the NDP. But it shouldn't say that we should, fold our hands because there is an early warning that we might not achieve the NDP goals. And therefore, the early warning says government does an introspection and accelerate the delivery of the priorities. It shouldn't become, the early warning shouldn't appear as something that has to demoralize us, but to fast track and to take forth some of the recommendations so that we improve. That's the nature of performance management. That's the nature of using research to assist the administration with decision making. So on the framework for the professionalization of the public service, the framework is in advanced stage and will go very soon to cabinet for approval in terms of implementation. So it actually deals with ensuring that we have a professionalized public service where appointments are based on meritocracy and also ethical public administration. And it also focuses on improving the leadership issues of governance and accountability, because this is a very instrumental aspect of ensuring performance of institutions. But also it considers issues around mainstreaming, gender, empowerment of youth and persons with disabilities, and the importance of social compact and engagement with key stakeholders. So those are the key elements that goes with this framework to ensure that we have a capable state that is ethical, but also developmental and through a partnership with the society. And with regard to issues around courses that are being offered by the National School of Government, I won't speak much on that. Colleagues from public service and administration will also assist on that. There was a concern that we raised that the bill was based on the testimony. It is also stated in the memo objects of the bill, and Dr. Schreiber has actually provided updates on that. The other issue when we talk about the comprehensive approach to building a capable, ethical, and developmental state is not only the law in terms of fixing some of the wicked problems, but there are soft issues that are very important in terms of you can have, let's say, a well-experienced, skilled accounting officer, but the environment might not be conducive in terms of performance. Hence, there are amendments that are done through the law to ensure that accounting officers are given also the functions of managing the human resource. So you cannot have, for example, DG only responsible to manage the budgets, but cannot touch human resource. These are two important resources for implementation of the strategic goals of the department, but also the other environment for conducive performance require a mutual relationship between the political head and the accounting officer, but also the relationship with political advisors. Some research indicated that sometimes you will get undue interference or instruction from political advisors, and this has to be managed through proper mechanisms, through proper continuous trainings on clarity of roles and responsibilities. But there are also issues around systems, around processes, around ethical behaviors that collectively has to be a comprehensive approach in terms of ensuring institutional performance. So it's not only about the law changing what needs to be done, but to consider soft issues. But also what we also encourage is not about focusing on an institution to deliver, but how does the institution deliver in a collaborative manner, as also included in Chapter 3 of the Constitution, that we don't only exist as individuals, but how do we work together across the three spheres of government? How do we work together on issues of common interest so that we are able to deliver services to our citizens? Then other issues with regard to the parallel part, this is an acknowledgement that the bill kind of aligned to what government is already working on. The issue in terms of the bills that are being initiated by government is that there are extensive consultation with the human resource because this laws touches human resource, and when you engage, you get new ideas, you get new inputs, and also there is a process of buy-in because the public service anticipate what is coming and prepare themselves so that come the bills being assented into law, there is efficient implementation. You don't have to deal with issues of change management or resistance because you would have consulted the public servants throughout the process. The other issues on SOEs, there are two aspects that I can talk to. We're looking at the efficiency in terms of institutional arrangements. So there is a process that look into whether certain SOEs has to be rationalized, have to be meshed. The rationale is to say how best do we reconfigure the SOEs in order to optimally deliver services, address the challenges that we have of poverty, unemployment, and inequality. So it's more about institutional arrangements for efficiency on delivery of services. But there is also other issues that deals with reforms with regard to, for example, the efficiency of the work that they are doing at operational level, issues of doing away with regulatory burdens, red tape, so that we are able to maximize the outputs that come from some of our key SOEs. So there are those kind of processes that are happening, institutional reconfiguration and efficiency at operational level. So with, I must indicate that the limitation, Dr. Schreiber, with the SEIAS here is that in our system, departments that develop bills and policies are the ones that complete the socioeconomic impact assessment template. We analyze. So now in this case, we didn't have the SEIAS report from the custodian of this legislation. We had to do our own analysis based on what was given to us. So that's the difference in terms of how we do SEIAS and how we have engaged with the private member bill. So those are Chair, some of the comments, and other inputs will come from the presentations coming from Dpsa as well as the Public Service Commission. Thank you very much, Chair and honorable members.
Thank you very much. Can I now invite the presentation by the Department of Public Service and Administration? But before that, let me allow the Deputy Minister to give her opening remarks before the presentation. Thank you.
Thank you once more, Chairperson, and again to acknowledge the members of the Portfolio Committee, the Chairperson of the Public Service Commission, the officials from Public Service Administration, and the Presidency. And Chair, to say that for this morning, we will be presenting to you the Public Service Amendment Bill. I must actually say that it has been very interesting listening to all these deliberations this morning, especially the comments that have actually been made around the economic impact assessment of the bill, the private members bill by the Presidency. And just to say that what actually just made me a little bit concerned is the spirit in which matters of this nature are actually put before us. And I guess most of the time what matters is the spirit that we actually utilize that will connect to the constitutional democracy that we have. If you look at the Constitution and the spirit of Ubuntu that is there, one wonders when we come into our meetings and have to have these deliberations as to whether we all the time consider what we have committed to as a country. And the one thing that I want to actually just endorse is that there is a challenge indeed, Chair, in terms of the interface between the executive and the administration. And I think these are matters that needs to be taken care of. These are matters that need to be looked at as we move forward in terms of legislative provisions that have to be made to manage to come up with a public service that actually manages to really perform at the highest level, because the people of South Africa are actually depending on us. And continuously there is also, I guess, I don't want to label it a feeling. It's utterances about the interference that actually happens within government, that actually manages that makes the work of the that makes operations within government to be a little bit difficult. But one other thing that is important that I think we are actually leaving out is the whole issue of performance, because also in terms of arrangements that we actually end up having within government, what's important is putting performance before everything else in order for us to, at the end of the day, to manage to meet the needs of the very people that we are actually representing when we are in government. My take is that when you look at most of senior management positions, they're no longer performance linked in terms of the kind of contracts that are actually developed for them. And these are some of the things that needs to, along the way, be taken into consideration. But coming back to the bill that is supposed to be presented this morning, Chairperson, the bill considers public service administration holistically looking at the high performance in public service that meets the basic needs of South Africans, maximizing the use of financing resources of the country, creating a people-centered, cohesive, synergized, efficient and effective public service. The bill also takes into consideration what is currently muted as the future of work. The bill strengthens the public service functions and structures to execute lawful practices as contemplated in Section 197 of the Constitution. The bill also considers the intent to professionalize public administration to ensure that the values and principles contained in Section 195 of the Constitution are realized. I just want to reiterate just the fact that the framework for professionalization of public service has not been finalized. It's still work in progress. The bill will improve the state's capacity by building systems, structures, processes, governance, instruments, technological and innovation that talks to smooth interface between the executive and the heads of the departments. Chairperson, let me take this opportunity to request the DG, Yolisa Makasi, to present to us the public service amendment bill.
Yolisa, you can take the platform.
Thank you, Chairperson. If I may just apologize, I'm using a different gadget and I'm unable to use the camera, so I request your permission not to show myself because the camera is not working on the laptop I'm using. Chairperson, I have on standby, firstly, good morning, Chairperson and the honorable members, including Deputy Minister, as well as colleagues from the Public Service Commission and the Presidency who have joined the meeting, and Dpsa colleagues. I have a colleague, Ms. Renisha, who's the Chief Director Legal, who's driving the process of the legislative amendments, who will be presenting. As she's preparing to present, I just want to highlight a few things as part of the introduction to the presentation. That we have a process of, we started a process of reviewing our regulations for the Public Service Act. We tried to wait and align the process of review of the current regulations with the Act and the amendments that are going to be done in the Act, but the amendment process is taking longer, and therefore some of the issues that we are dealing with the review are urgent, and therefore we have decided to go ahead. So a number of issues in the regulations we're looking at in terms of review, especially our HRM, human resource management and development related regulations. Also, we will be issuing the regulations under PAMA on ethics and corruption have been finalized. and we are going through processes to implement those regulations. Now, in terms of just a few things I wanted to highlight, Chair, in the responsibilities for Dpsa in terms of the NDP are carved very well in Chapter 13. And various departments have responsibilities, but our responsibilities as Dpsa are carved in that document in Chapter 13. And we haven't come to the committee as Dpsa to indicate that we won't achieve our specific targets. We're working around the clock on our specific Dpsa targets in relation to the NDP. We could come back at the right time to brief the committee on those matters. On the professionalization of the public service, when I checked with the School of Government, the principal, he had indicated that they will be ready to submit the framework to Cabinet for consideration during the month of June. It's a matter that we're following up. What we have done as Dpsa is that we have already aligned our proposals on certain matters aligned to the on the amendment bill to the professionalization framework. Because that framework provides a policy basis in relation to a lot of work that we want to do in professionalizing the public service. I am not sure if the Public Service Commission has done the same in terms of that alignment, because also some issues around the role of the public service in terms of driving this meritocratic government, etc., are also encompassed in the framework itself. So I'm not sure, but the Public Service Commission, it's an issue they can look at it if they haven't looked at that particular issue. On that note, Chairperson, I'm going to hand over to Ms. Renisha, who will take the committee briefly through our amendment bill. This amendment bill was meant to have been submitted to Cabinet, to Parliament by the end of the previous financial year. However, that did not happen as planned because the consultations at the Bargaining Council have taken longer time than it was anticipated, and we're still due to go through the NEDLEC processes of consultation. So we have committed that the amendment bill should be, we will push for it to be submitted before the end of this financial year to Cabinet, to Parliament. Thank you, Chair.
Thank you. Who said must come in, Yolisa?
It's Renisha, Chairperson.
Okay, she must take the floor.
Good morning. Good morning to the Chair. Good morning to the members of the committee. Good morning, DM, DG's colleagues. Chair, if you don't mind, I'm going to switch my video off so it doesn't interrupt the network.
Okay, you can switch it off.
Thank you.
Who is that? Hey, Liako, come on.
So Chairperson and members of the committee, the presentation that we are presenting today, we are trying to give the committee a sense of a process that we came to the committee in March of last year, where we are with that process and how far we have taken the process and what we anticipate the process to be. So in that light, we have provided some context, some progress, as well as we've highlighted some of the amendments that are taking place. Chair, with your permission, when we started this process in March of last year, we came to the committee and we said we were going to draft bills that we're going to give effect to the National Development Plan and the professionalization work that was being undertaken. In that context, we looked at the bills from a very holistic perspective, with our main goals focused on how these bills assist in service delivery. And when we talk about service delivery and public administration, we have to look at the four elements of the public administration, being the citizens and how citizens benefit from these bills, how government benefits in terms of meeting its obligations, as well as how services themselves are rendered by the public servants. And our fourth element is the public service
officials themselves. So we looked at all different areas as we dealt with these bills. As the DM has said, we looked at these bills holistically to take into account those 4 pillars that I mentioned. And to that extent, I think DM has elaborated on what our intentions were with these bills. So I'm not going to repeat it. Chair, in terms of progress that we've made, so we started this process in 2019. We came to the committee and we gave a sense of what were the policy areas we were looking at for the amendment of the 2 bills, or the 2 acts, which was the Public Service Act as well as the Public Administration Management Act. Since our last engagement in March, we have drafted bills, and I'll talk to the content, but we have drafted bills. We've submitted it for public comment. It was published in the Government Gazette for public comment on the 6th of April. We had extensive consultation processes on both these bills. There were certain issues or certain requests for longer periods for the consultations. In terms of the public consultation process, we extended it until the 21st of May where we were requested. In terms of the comments we received, you'll see the numbers there. We had 13 institutions or persons giving comment on the Public Service Amendment Bill and about 19 on the Public Administration Management Bill. Chair, I want to emphasize that these look like 13 and 19 being small numbers, but they were in excess of 100 pages of comments. So the bills were quite extensively canvassed publicly. In addition to the public consultation process, Chair, in terms of processing bills that have labor implications, we are required to consult with the Public Service Bargaining Council as well as the South African Local Government Bargaining Council, because the Public Administration Management Bill affects municipalities and local government. So there was a requirement also to consult at a local government level. In addition to this, Chair, as part of the processing of the bill, we are required to go to NEDLAC. So at the moment, we are currently still in the bargaining councils. The minister there has been a request for more consultation to take place at the bargaining councils, and that extension's been granted. We are currently in that process of dealing with those consultations. I think the committee will appreciate that these bills have labor implications, and we must try and deal with these matters in these councils as well and take into account those inputs. So, Chair, our intention is to conclude these PSCBC and SALC-BC processes shortly, which will then allow us to go into the NEDLAC processes. Chair, just with the understanding that the documents or the areas we are canvassing today are subject to change. They are subject to discussion within the bargaining councils. We don't want to undermine those processes as well. So respectful of those processes, we are presenting these areas of amendment that are currently in these different bills. So, Chair, on the Public Service Commission, the Public Service Amendment Bill, there are a few areas that we've highlighted. There are other technical amendments that are being done, but the main areas that need to be brought to the attention of the committee at this stage is that the bill seeks to devolve administrative powers to a head of department, but we have, through these processes, also sought the objective of retaining strategic powers with relevant EAs. The bill, if you look at the draft, it's quite detailed in terms of what powers are being devolved to HODs and what powers are being retained at a strategic level. These bills are also taking into account checks and balances to ensure that the administration is not affected by these changes. The second area of amendment is also, as the presidency has alluded to in their presentation, to augment the functions of the DG in the presidency to include functions that are envisaged by the National Development Plan, for the DG in the presidency to play the role of administrative head of the public service. The first two bullets, Chair and committee members, is to deal with the political administrative interface of that we spoke to earlier. The third amendment that's important to highlight is the role of the Public Service Commission in determining internal grievance procedures. Currently, the procedures that are in the public service have been dealt with by the Public Service Commission and have been concluded through the bargaining processes. There was a requirement to clarify the role of the Commission so that the Commission is no longer responsible for the internal grievance procedures. However, the Commission retains its ability to deal with procedures that are required to be regulated for the submission of grievances to the Commission itself. So there's a delineation between internal procedures and procedures that employees will use to refer matters to the Commission. The fourth bullet, Chair, is again in keeping with the Single Public Administration Initiative, where we have had to consider what was in the Municipal Systems Amendment Bill. At the time we had redrafted during these processes, we had looked at the provision on the prohibition of employees holding political office. We had aligned ourselves with the Municipal Systems Act, which was submitted to Parliament, which basically looked at municipal managers who were prohibited from doing business, municipal managers that were prohibited from holding political office. So what we did was we aligned our amendment with that principle in mind, but we have noted since that the prohibition now extends to all employees, and it's something we will consider to align with the Municipal System Act. Chair, the last major amendment that the committee should note is that Section 38 of the Public Service Act, or a portion thereof, was declared unconstitutional, and the requirement is that we must amend that provision to ensure that it falls within the constitutional imperatives. To that extent, we have provided in the amendment bill a mechanism for departments to lawfully deduct overpaid remuneration from an employee's salary. As we did that process, we had to make sure that the provisions were clear enough to ensure that employees' rights were not eroded during that process. Chair, the second bill that is under amendment, or the second act that is under amendment, is the Public Administration Management Act. This act was promulgated in 2014, so it's a fairly new act. The provisions of this act have not been fully implemented, and the reason it hasn't been is because some of the provisions in the act have become difficult to implement. They also require regulations to some degree. To the extent that they need regulations, we have, as the DG has indicated, we have processed regulations, and we are hoping to implement those regulations in the forthcoming financial year. But Chair, just to note that the amendments of the Public Administration Management Act address some of these legal challenges. Some of the provisions that we have included and that are still under consideration at the bargaining councils is that we have made provision for transfers of employees in some sectors to be done without consent where it is in the public interest and operationally justified. To that extent, we have provided in the bills, which is still, again, I want to reiterate, a discussion between in the PSCBC and in the SALG-BC. We have distinguished between transfers in the public service, where we say that if there are employees being transferred within national and provincial governments or departments, they can be transferred without consent if it's in the public interest. That's a provision that is currently in the Public Service Act itself, which we want to replicate in this Public Administration Management Act. And where there are transfers of officials between municipalities or between municipalities and the public service, then that will be done with the consent of employees, noting the different conditions of service that exist in these areas. The second amendment, Chair, that we are looking to deal with is the removing of unintended consequences. This is particularly in relation to doing business with the state. So what we do is we clarify what we mean by the state. We also clarify concepts of what it means to be doing business with the state, so that we don't have teachers, for example, who are required to mark exam papers being prevented from doing that. So the amendments are dealing with those technicalities. The third amendment, Chair, is in terms of the National School of Government. When the Public Administration Management Act was passed in 2014, it created the National School of Government as an institution of higher learning, so under the Higher Education Act. Through our processes and engagements with the National School of Government, we have determined that this provision is very difficult to implement in its current form. So the proposed amendment is for the National School of Government to be retained as it currently is as a national department. However, we are proposing to still retain the ability of the National School of Government to provide education and training to all spheres of government, which includes municipalities and public entities where public entities require or request that assistance. The next area of amendment, Chair, is the removal of unfair disparities or unjustifiable disparities in the public administration. And this is particularly in relation to remuneration and other conditions of service that exist across the public administration. That means between national government, provincial government, municipalities, and to some extent, we are also extending this provision to public entities. As part of that process of removing unfair disparities in the public administration, we are also looking at provisions to regulate the mandating arrangements for collective bargaining in the public administration so that there is better coordination in those processes. So that work is still under discussion and underway. Chair, in terms of the way forward, it is expected that, as I said, we will conclude the PSCBC and SALBC processes shortly. And we are hoping that we will start the NEDLAC processes and conclude those NEDLAC processes by the 30th of September 2022, which will then allow us to finalize those bills and submit it to Parliament by the fourth quarter of the 2022-2023 financial year, which is this year. Thank you very much, Chair. DG.
Thank you. DG, come in.
Thank you, Chair. I am good with the presentation. I have no further comments. Thank you, Chair.
Thank you. Can I now allow honorable members to discuss this presentation? Can you do that by show of hands? I see Honorable Schreiber's hand is up. Can you take the platform, Honorable Schreiber?
Thank you, Chair, and thank you very much for the presentation as well. Just one question on the proposal there regarding the prohibition on political office bearers from being employed as HODs or DGs, so as heads of department. If you look at the Municipal Systems Amendment, they initially started at municipalities a few years ago with also only prohibiting the senior managers from holding political office. But there were some problems that arose with that because then you had more senior political officials lower down in the administration who were actually interfering with the work of the more senior officials who were not members of political parties. And that's one of the reasons that's motivated the recent amendment, which has actually expanded this prohibition to all workers, all employees in municipalities. And I think that's something that's been widely welcomed also in the National Assembly. So my question is, why would this amendment not also extend the prohibition on political office bearers from working in the public administration throughout the entire levels of public administration? Why only limit it to the heads of departments or directors general, especially given, first of all, the experience in municipalities that shows that this creates new problems, and secondly, also the recent amendment, which would be quite unfair then on some other officials who are prohibited, while leaving open the door for lower level officials in the public administration. So you create a discrepancy. Isn't it more reasonable, practical, logical to actually similarly prohibit political office holders from being employed throughout the public administration entirely? Thank you very much, Chair.
Thank you, Dr. Schreiber. I don't see any other hands want to raise questions. I will therefore allow now the department to respond to Honorable Schreiber's question.
Thank you, Chairperson. I'm going to hand it back to Renisha to respond about what Dr. Schreiber is actually articulating to as the discrepancies with the Municipal Services Amendment Bill, so that she can actually give that clarity.
Thank you, DM. Honorable Member Schreiber, when we started this process of amending the legislation, we were very cognizant to align with what is in the municipal space, because that's what the Single Public Administration Initiative required of us. As we considered these matters, I think one of the difficulties we have in this space is to ensure that we don't erode constitutional prerogatives of people. Initially, we started and we aligned with, if you look at the bill that was submitted by COCTA in terms of the Municipal Systems Act, there was a provision to limit it to municipal managers and those members reporting directly to municipal managers. So as we went through the process, we then engaged on what was justifiable in terms of a limitation on the constitutional rights of people. And one of the elements we looked at was what then are obligations of employees in their respective roles. And we looked at what was the obligation of an HOD and how that would conflict if that HOD held political office. And political office is also a limited definition. We have since been advised through the processing of the Municipal Systems Act that provision has been extended to all employees. So we will, as part of this process and our further engagements, continue to engage on that matter to ensure that there is alignment with what is in the municipal system space. But again, we are very cognizant of the constitutional imperatives that we must be careful of. Thank you.
Thank you very much. I can see now there's a hand up from Honorable Mkweba. Honorable Mkweba, take the floor.
No, thank you very much, Chair. If the problem is that it's very difficult to engage to these reports, now that you have said the first presentation will be debated or discussed in the next meeting. But however, Chair, let me also appreciate the progress report by the Dpsa and have two questions to the department. Firstly, my interest is which group between individuals and institutions, because they've said the true public hearings or through public comments, there were groups and individuals who participated to the bill. So my question is that between the individuals and institution, which ones had more interest to comment on the bill? And what is the conclusion based on their interest? Is it because the amendments will help individuals or the system of governance, or both? So that's the first question. And the second question, on the way forward to the document, they spoke about the PSCBC. And we understand the bill was first presented to the PSBC on the 5th May 2021. So my question, Chair, is that since then the bill was presented on that month of May 2021, and we understand the negotiations are still continuing. Do they think that they are on track and the bill will be tabled on time to Parliament for further processing? Those are the two questions, Chair. But however, I think one must note that you have said all the discussions will be then done in the next meeting, which is, I understand, that will be between July and August. Thank you very much, Chair.
Thank you, Honorable Mkwaba. The reason, honorable members, I say we must not discuss today. You have received the presentation from Honorable Dr. Schreiber. I want you to study that presentation, and then in the next meeting, you engage effectively with what Dr. Schreiber has presented to the committee. That's the only reason. If there is no other person who want to raise question, can I allow the department to respond?
Thank you, Chair. The question is requiring detail that relates to the process when we took the document out for input. And I'm going just to ask Renisha to just give a high level around some of the organizations that had made comments and the number of individuals as well, and then how we process those into the document, if there's any of those that had come through out of that process that finally found expression in the document. I don't know if Renisha, you can be able to think about that at the moment, but I'd just like you to try and give a broader view on that question.
Take the floor, Renisha.
Thank you, Chair. Thank you, DG. The comments came largely from organized labor, from provincial administrations, as well as public sector institutions like the Helen Suzman Foundation, etc. I think the overall picture of the inputs was largely supportive to the drive to amend these pieces of legislation. There were suggestions on how the bills could be made better, which some of the suggestions we have incorporated into the bill. Largely, some of them were technical, some were policy driven, and we have then looked at our policies to that extent that it required. So, Chair, in a nutshell, I think the comments were very supportive to this process. There was general buy-in on the amendments. Our challenge is to process them through these processes that are required. And to answer maybe DG the second question on the on whether we envisage that we will table these bills into Parliament this year. We have already engaged with NEDLAC on the process. So NEDLAC is aware that we are bringing these bills to them. We have requested an expedited process at NEDLAC. But again, that's not to undermine the NEDLAC processes. We will try our best to get these processes concluded. If we are able to, and which we expect to do by September, then we are for certain going to bring these bills into Parliament in this year. The plan as it stands is on track, so we are confident that the bills will come to Parliament in this financial year. Thank you, Chair.
Thank you very much. We will now invite the Public Service Commission, and I will allow Professor Fikeni to make his opening remarks before the presentation is made. Professor, you can take the floor now.
Thank you very much, Chairperson, honorable members, for this opportunity to make some preambling remarks on the PSC bill. We've been working on this bill, and before I even say that, let's convey our gratitude and thanks to the Portfolio Committee under your leadership for having expedited the appointment of commissioners into the national office. We now finally have the 3 new commissioners who have been appointed by Parliament, and the Presidency did actually finalize the process. They started, Professor Makanya, who is in attendance, started last week. We also appreciate the fact that out of those commissioners, 2 are women and 1 is a man. That affirmation and the issue have always raised that the bias was always towards men. We now have that 1 remaining commissioner that still has to be filled in the national office. In the same vein, we should say, whilst you did your part, there was a delay of 2 months, which was quite inexplicable before we could receive the appointment of these commissioners. Something that in future we should look into if we're talking about PSC's independence with no hindrance. I just want to say, before I invite Commissioner Boshoff, who has been asked and tasked to work on the PSC bill, having led that process, working with Commissioner Sizani and consulting widely with Dpsa, with different relevant stakeholders, I want to say we will come and go in the roles that we occupy, whether we are commissioners of the PSC or members of this portfolio committee. But future generations will ask, when we observed the weaknesses in the institutions of public service, what did we do? And was our intervention impactful? Was it timely? And therefore, that in itself, I think, is the context within which we should be looking at this priority that government has put as the building of a capable, ethical, developmental state. The current policy reforms that have been presented here, from the presentation by Dr. Schreiber to the presentation on the impact assessment by the Presidency and the presentation by Dpsa, attest to a number of policy reforms which are meant to help with the building of a capable state. But I think is most important is how do we put all these pieces of the puzzle actually, and not use the fact that they are here, all of them, as a reason for further delay. PSC bill is meant to simply give the real and true meaning to its constitutional mandate, being that autonomous entity. Because we did say this to the meeting with the Speaker of Parliament and her team. We did say this for the committee to say there are major contradictions on the PSC being expected to exercise this oversight or this role, which is mandated in Chapter 10 of the Constitution, but at the same time being constrained by being under, the supervisions of departments, not being treated the same way as the other commissions. There are major inherent contradictions there. This bill is meant to deal with just that, so that one day we are not challenged by a private citizen who will go to the Constitutional Court and say APCTE is not constitutional. This is a preemptive move, but an end one. Also to give to what PSC can do, rather than the current situation where recommendations are ignored. And to me, I just want to appreciate all presentations that have been made and simply say we should find a way of sequencing them, appreciating their complementarity. And I now invite Commissioner Boshoff to just make a high-level presentation on the PSC bill and the work that has been done so far, hoping that you will assist in making sure that this is a priority bill rather than the one that takes too long in an interregnum where the old takes too long to die and the new takes too long to be born. Thank you, Chair.
Thank you, Professor. Commissioner Boshoff, you can take the floor.
Good morning, Honourable Chairperson, Honourable Members, Deputy Minister, and all staff members. I think that the purpose of today's presentation, Honourable Chairperson, is just to update the Portfolio Committee on the progress we have made with regards to the draft PSC bill. I'm just going to provide a high-level summary, and then I'm going to request the Director General of the OPSC just to go through the presentation that is currently on your screen in more detail. But with regards to the progress that we've made, the Public Service Commission started with this process in 2014. And let me also indicate that the honourable members who have already spoken this morning have actually made my life very easy, because everything we want to achieve in the draft bill have been raised by the honourable members. They've addressed our frustrations, they've addressed the challenges that we have identified with regards to our independence, and we have attempted in the draft bill to address all of those. So in 2014, having studied the Kaida Osmal report, where it was clearly stated that being supported by a national government department has the potential of the PSC's independence being compromised. It was earlier also referred to by honourable members. More recently, the same challenge was also identified in the National Development Plan, and the intention is then obviously to address that by creating a secretariat for the Public Service Commission, where we will be supported by our own administration, headed by a Chief Executive Officer, and not by department, a national government department headed by Director General, that is, as is the case at the moment. So, honourable members, the main focus of the bill is basically to repeal the Public Service Commission Act of 1997 and to replace it with something completely new that addresses all these challenges, frustrations, etc. And then ultimately to create a secretariat for the Public Service Commission, as I've already mentioned. But we would also like to strengthen the remedies that are available to the Public Service Commission to ensure that it executes its mandate as was intended in the Constitution. Then also very importantly, honourable members, in 2011, the National Assembly took a resolution that the mandate of the Public Service Commission should be extended to also include local government and public entities. We have considered that. We have included that instruction of the National Assembly in our draft bill, and that is something that we will debate further. Now, honourable members and honourable chair, we have concluded almost all processes leading up to finally submitting the bill to cabinet. We have finalized the cab memo, the draft bill. The draft bill was submitted to the Chief State Law Advisor on 2 occasions. We've incorporated the inputs. We have finalized the business case. I heard the Presidency earlier referred to the business case of the Public Service Commission. There is a comprehensive business case available, and they can perhaps, we will share that with Ms. Corlett. And then we've also finalized the socio-economic impact assessment, and a certificate has also been issued by President. We met of Service and Administration the 8th of May. The process with supporting documents was well received, and they asked before to request the Director General of the Office of the Public Service Commission to present the presentation. Let me also indicate, and we are very excited about this, we, on 26th of May, we received a letter from the Speaker of the National Assembly confirming that a letter was received from the Leader of Government Business, the Deputy President, in which he informed her that Cabinet took a resolution on the 11th of May that the proposed bill will now be included in the 2022 legislative program. So we have, for now, finalized our process. We have submitted all the documentation. It is with the Minister, Acting Minister of Public Service and Administration. It is our hope that the Cabinet memo will be tabled before Cabinet as soon as possible, whereafter we can start with the processes of tabling it to the Portfolio Committee, going through all the consultation processes, etc. With your permission, Honourable Chairperson, I'm now going to request the Director General, Advocate Dinky Dube, just to take honourable members through the detailed presentation. Thank you, Chair.
Thank you. You can take the floor, Dinky.
Thank you very much, Chairperson and members of the committee, Deputy Ministers, Commissioners, and colleagues for the opportunity. As Commissioner Boshoff has said, the presentation is really meant to update the committee on where we are with regards to the Public Service Commission bill. By way of an overview of the presentation, we thought we should just touch a little bit on the background where we come from with the PSC bill and why it's important that we amend the current legislation. We'll also talk to you about our institutional practice review, which resulted in a very comprehensive business case, as Commissioner Boshoff has said, and also talk to the proposed amendments of the legislation, many of which you've already heard through the meeting today. We will also just reflect some of the comments we've received from our sister department, the Dpsa, which was then amended effected into the bill, and as well as where we are with regards to the socio-economic impact assessment process, as well as reflect on the key milestones to date since the drafting process has started. I'm not going to dwell much on the background because I believe Commissioner Boshoff has covered it. What is important, Chair, is to indicate that, as it has already been said earlier, that the Public Service Commission is the only constitutional body that is currently supported in terms of secretariat by a national government department. And so this current institutional framework renders the effectiveness as well as independence of the PSC quite challenging, Chair. We've already had the need earlier on to have its own secretariat to ensure that it operates at an arm's length from the government. So what then has happened is that the PSC embarked on a project, institutional practice review project, which really looked at the current institutional framework to explore ways in which that can be strengthened. That resulted in a business case. It is quite comprehensive, which then, of course, also the process of drafting the Public Service Commission bill comments in earnest in 2020. The primary objective of the bill is really to ensure that the PSC has its own secretariat. As part of that, a number of benchmarking studies were done with other Chapter 9 bodies, for example, your Human Rights Commission, your Gender Commission, which as a constitutional entity, they've got their own secretariat and not supported by a government department. And as part of repositioning of the PSC, it was important to ensure that it is effective in executing its constitutional mandate. So what are really the areas of focus in the bill? The first one is, of course, will be to repeal the current Public Service Commission Act and replace it with a new legislation. We'll also ensure that the PSC is able to operate independently and as an impartial constitutional body with its own secretariat. We believe that this will improve our efficiencies in terms of the impact we want to have in the public service and the public administration. What is also important, as Commissioner Boshoff has said, is that the mandate of the PSC will also be extended to municipalities and public entities. Committee members will know that currently the PSC is only mandated to conduct investigations within the national and the provincial departments only. So with regards to what we foresee and the objectives of the bill is to ensure that the Public Service Commission is listed as a constitutional institution in terms of Schedule 1 of the PFMA, because it is currently the only public constitutional body that is not listed in the PFMA. Of course, the chair has spoken about ensuring that we have more teeth. And so with regards to the bill, we envisage that our enforcement mechanism will be improved when we look at the institutional framework that is currently hampering the effectiveness of the PSC. A part of the bill is also to then ensure that the conditions of service of commissioners is aligned with the determination of remuneration of public office bearers as clarified in the PSC Act, because currently commissioners, the conditions of service are determined via the MPSA, and they are aligned to the public service regulation. That too is also an area that needs to be corrected, because if you look at all the other constitutional bodies, the office bearers, the conditions of service are determined in terms of the determination of remuneration of public office bearers. And so what are the proposed legislative amendments? primarily, as we've said, is to establish a secretariat for the Public Service Commission. It will then replace the current Office of Public Service Commission, which is a national government department, and ensure that the PSC executes its mandate fully as an independent and impartial constitutional entity. So the OPSC, which is the National Government Department, will then have to be removed as a government department in terms of the Public Service Act, and the human resources in terms of the transitional arrangement will then ensure that they are transferred into the new Secretariat of the Public Service Commission. Of course, we envisage the mandate to be extended, because if members would recall, Section 195 of the Constitution, the constitutional values and principles apply to public administration, and the PSC is mandated to promote the CVPs. However, insofar as investigations are concerned, the mandate of the PSC is only limited to national and provincial government. What we have listed here are those proposed legislative amendments that will not only deal with the constitution of the commission, the process of appointment. The acting chair has already spoken about what then happens administratively after the parliament has done the interviews. We would want to ensure that in future, the delays that then happened are hopefully averted. And of course, the establishment of the PSC Secretariat would need to put in place proper transitional arrangements with regards to the current employees of the OPSC. We have received comments from the Dpsa in the various drafts of the bill, and mainly the one comment that the Dpsa has provided to us was to ensure that the employees of the commission, the newly formed secretariat, the conditions of service are still determined in line with the public service determinations, which of course we agree with that. We are mindful of as well of the escalating wage bill, as well as to ensure that there is parity across public administration. The second one was to ensure that the officials that are currently appointed in terms of the Public Service Act will then be in future be appointed in terms of the new Public Service Commission Act, because they will form part of the Secretariat. I've already touched on the issue to ensure that the conditions of service of commissioners are determined in the same manner as other public office bearers. Insofar as the socio-economic impact assessment process, when we started the drafting of the bill process, we engaged with the presidency, and they've advised that the SEIAS process must be completed in 2 phases. The stage 1 is really at the beginning of the bill, as my colleague from presidency had alluded to earlier. However, in respect of the PSC bill, because a comprehensive business case had already been done, we have then been granted an exemption to the stage 1 of the SEIAS. So we are now at the stage 2 process to complete the socio-economic impact assessment. What we have reflected, Chair and the committee members, is the various key milestones and activities that we have undertaken in respect of the drafting of the bill, commencing from in 2020 with the meetings, various consultations with the Minister of Public Administration, the DM. Of course, internally, we had our own internal workshop. Throughout the year of 2021, we also had quite a number of engagements with the ministers at different intervals as we were continuing to update the bill. Perhaps it is important to highlight from this financial year what has happened. We have received the pre-certification from the Office of the Chief State Law Advisors. That was in January 2022, where they indicated the overall support of the bill. They have suggested many minor amendments, which we have already effected into the current bill. We've also had meetings with the MPSA after having updated the bill with the comments from the Chief State Law Advisors. And in the meeting of the 24th of March 2022, the then minister had then requested us to really expedite the process and ensure that we start drafting cabinet memo and ensure that all the necessary annexures are prepared for submission to the minister, so that then the legal services of the department has also an opportunity to give their input. The commissioner has already indicated as well that the commission had an opportunity to also meet with the speaker and the deputy speaker of the National Assembly in April, in which the speaker had indicated that the bill needs to be included in the list of legislative program for this current financial year, of which we can confirm that that has subsequently been done. We, of course, prepared the documents for the MPSA with a view to tabling the draft bill to cabinet. That was in April, and we have been engaging with the DG, Dpsa and colleagues, and we're still awaiting, of course, the comments to ensure that the minister is happy and has provided go ahead for it to be tabled to cabinet. We've also heard earlier about the role that is envisaged of the PSC in terms of the National Development Plan. Of course, on the 10th of May, we had an opportunity to meet with the National Planning Commission, and it reiterated its support of the PSC bill to really deal with the issue of independence of the Public Service Commission. The chair, we subsequently also had an opportunity to brief the current acting minister of MPSA, and he's also provided his support and the need to ensure that the tabling to cabinet is expedited. On the 25th of May, we received approval from the Presidency and the SEIAS unit for the bill to be tabled to the cluster. And as Commissioner Boshoff has said, we've also been informed that the Cabinet has approved for the Deputy President as leader of government business to really oversee the processing of the bill so that we ensure that it is expedited. This is what we envisage, Chair, will then take place once we've gotten Cabinet approval for the processes of tabling of the bill. As a way forward, Chair, it is really for the PSC to request the guidance and support of the Portfolio Committee in moving forward to this bill, as our anticipation is that this should be finalized by the end of this financial year. Thank you very much, Chair. That brings me to the end of the presentation. Thank you.
Thank you. I will now allow honorable members to raise hand. I can see Honorable Nduli's hand is up. Honorable Nduli, take the floor.
Thank you, Chairperson. And one would love to welcome the presentation of this of the Public Service Commission bill. Safe to say, Chair, this amendment bill is seeking to address a lot of issues that have been raised by this Portfolio Committee. And without much to say, one would wish the Public Service Commission bill a happy birthday without any hindrance or any blockages. And today, Chair, I think I must correct myself. I recall that I would always ask a Public Service Commission about their teething. It was clear that they were not going to have any teeth without the birthday of this bill. That is the long and short of what I wanted to say, and hoping that really before the end of the year, we are going to see the fruits of this progress. As a professor alluded to, on the delays in most circumstances. Good luck, Public Service Commission, with the bill. Thank you.
Honorable Mbele, take the floor.
Thank you very much, Chairperson, and thank you to the Public Service Commission for their presentation. I'm going to give the preface that my question is a provocative and challenging one. So the respondent from the PSC must just be ready for that. But it's a thought that occurs to me. Now, I know that across sectors of society, we have different perspectives and outlooks and paradigms as to how processes and approaches should be. So mine is a alternative one that I know challenges the orthodoxy. And it was triggered by the explanation of the process that's been followed so far in terms of this draft bill by the PSC. In particular, there was this notion of awaiting and receiving approval in order for the bill to be processed through the cabinet cluster mechanisms and to be tabled before cabinet. Now, that I found a bit jarring because of the nature of the PSC as a chapter, sorry, not chapter, is it chapter 9? No, it's not chapter 9, but its nature as an independent institution that stands above and separate from the executive and the normal sort of architecture of government. Just to very quickly quote section 196, subsection 5 of the Constitution dealing with the PSC, which says the Commission is accountable to the National Assembly. And linked to that as a secondary issue is the fact that the National Assembly appoints PSC commissioners. Now, I understand the need for and the importance of consultation, harmonization within the framework of cooperative governance. But I'm just wondering, what was the obstacle or the hurdle for the PSC to do their own internal thinking, brainstorming, and strategic outlay of what they need and the reforms that would assist and maximize their efforts, and then simply bringing this bill to the committee and to Parliament, table it, get it processed. Again, I don't want to negate the importance and the need and the value of consulting with the executive and cross-checking and cross-referencing implications with other departments or whatever the case might be. But I'm just worried, it gives me anxiety when what are meant to be independent institutions that are monitoring and advising and giving direction to departments and to the executive seeming to subsume themselves to the normal protocols and processes that should not and officially, constitutionally do not constrain them. So I know that there's a challenging question to the orthodoxy of how things tend to work in our state architecture, but I just want to sort of pinpoint and highlight that as a problematic sort of paradigm. The PSC could have, and I would say should have, been able to get this processed and taken to completion a lot quicker if there wasn't this sort of preemptive deference to the executive, which they are in no way obliged to follow. Thanks, Chairperson.
Thank you, honorable members. We're now going to deal with that was the comment, Honorable Mbele, or were you expecting a response? Let me check with you first.
Chairperson, I would appreciate a response, but as I said, I know it's a challenging and unorthodox ones for you know, in our current milieu. I would appreciate one as best as they can, but I thought it was an important high-level point to make.
Okay, let me allow them to respond then.
Thank you. Thank you.
I just want to respond rather directly before Commissioner Boshoff comes in here to what I think it's a provocative and a rhetorical question, but a necessary one. The PSC, according to the Constitution, is appointed by Parliament and accounts to Parliament. Putting the same question differently, one, the context matters. We are appointed and we account to this august body. And we find certain arrangements, such as the presidency will sign the appointment, the processing by Dpsa, and so forth. I wonder if it would not have been the Parliament to which we account, which would have initiated some of the measures to say we would want the appointments of the commissioners to go straight to the presidency for signing and you know, taking effect. The same Parliament would say we would want the PSC not to be called in to present on matters that may affect the same department, Dpsa, and be made to sit there and pronounce on those issues. And whether the Parliament wouldn't have had a greater muscle to approach the President, the Speaker, and others to say, this current arrangement has its own challenges, rather than the PSC in a corner trying to craft and rearrange this institutional arrangement. Because I think the Parliament has greater clout than those who are appointed by Parliament and account to Parliament. So to me, even the arrangements that we normally have every time we come to present, sometimes on the state of public sector, and sometimes on issues that affects the very same department that we're invited to present under. We're invited into the same meeting, and sometimes we've even had, you know, the situations where we are told these are the entities of the department, and we try to correct that. So I do think that it might just help for Parliament to give guidance and engage with the executive and so forth. With us, we had to consult with the department. We had to consult, with the various stakeholders because of the complementary roles which are there. And I'm sure our Honorable Deputy Minister and colleagues will assist in that sense, because some of these arrangements, we find them already there. And some of the proclamations by the Cabinet on what should happen are already there. And some of the protocols are already there. So to me, I do think that it's a bit awkward to put this to the PSC itself. PSC had to do its best within the context it inherited. Thank you.
Thank you, Commissioner Boshoff. Can you come in?
Chairperson. Chairperson.
What's that now?
Yes. It's a follow.
Deputy Minister.
Yes, I just wanted
to make a follow-up.
Yes, follow through on a point that has just been made by the chairperson of the acting chairperson of the Public Service Commission.
Okay.
Which is something that is important in terms of actually giving some kind of clarity and direction that relates to the discussions that we're actually having now. Because even with the presentation itself, when one was actually looking at it, one could actually have this sense of discomfort and sense of a little bit of confusion as to how to actually place this. But let me just indicate that up until now, the department has actually been responsible for the bill, working jointly with the Public Service Commission, because of the kind of arrangement that we've got now that is actually guided by the Public Service Act. And lately then, what is understood is that maybe the bill must actually be handled solely by Public Service Commission, which will actually leave us with a situation that may not be desirable. And it may not be desirable for matters that have actually been clearly articulated by the acting chairperson. If we come to the conclusion that the Public Service Commission reports to Parliament, which was not the case up until now, because we know that Parliament is responsible for Chapter 9 institution, that is institutions supporting democracy. Even if Public Service Commission is supporting democracy, it's actually doing it in a different chapter of the Constitution. So if that is the case, then it means the sponsor of the bill should then therefore be the Speaker of Parliament. But for now, I think looking at the current arrangement, the current system that we've got, the sponsor will continue to be the Minister of Public Service and Administration until such time that the competency has actually been extended to the other side. And for me, this is my understanding of it. And in terms of the processes also, I think this is why there's been confusion. Then you hear that there's been contact with the Office of the Speaker. There has been contact with the leader of government business, when in actual fact there is the bill-making processes that are actually known and acknowledged, because bills should actually come from Cabinet into Parliament through the leader of government business. This is the process that is actually embarked on when a bill comes into Parliament. And then from the Office of the Speaker, then it will go to the Chair of Chairs, and then it goes to the committees. So basically, I think what is important, which we will do moving forward, would be to sit down with the Public Service Commission so that we actually together craft a better way forward, so that our approach shouldn't be something that is a little bit scattered like it is now. And I think it will be helpful, especially also to bring closer to us the State Law Advice Office, because when it comes to the legal expertise and technicalities, this is the institution that we are currently depending on in terms of crafting this bill, because there is a lot that needs to be taken into consideration legislatively as we actually make amendments, so that we don't make amendments that are actually finally going to put us in a position where we find that things are a little bit difficult because of the kind of bill that we've actually finally come up with. And also to look at, in terms of consultations, as to whether we have actually thoroughly consulted on the bill. We need to be conscious of that. And I'm sure even the portfolio committee itself will be interested in that, as to whether we will have consulted enough. And I'm sure even Labour itself will be very much interested in the bill and the outcome of the bill. Thank you, Chairperson.
Thank you, DM. I see there's a hand up. I don't know whose hand is that. Or is Professor Fikeni? Professor Fikeni, can I allow you to?
Yes. Well,
Yes.
I do think that it might help Honorable Chair and Honorable Members, Honorable Deputy Minister and colleagues from Dpsa to give the context to why we had a meeting with the Speaker of Parliament. Speaker of Parliament said, I'm new. I want to understand the PSC better. And PSC said, we also need guidance on our interface with Parliament, because at times, there was a time we were called by different portfolio committees and one time by SCOPA to come and present. And we were told that's not how it should be. So that meeting was arranged. We met, and she also said we need to present on this proposed bill for her to understand better and her colleagues to understand better. It was not in any way to undermine the existing protocols, but as an entity that is written down as accounting to Parliament, mindful of the current PSC legislative condition and prescripts. We met, and we also reported to the Minister of Dpsa or the MPSA, the acting minister, to say, we have such a meeting, and we also indicated we had such a meeting. We also reported to the portfolio committee as well to say we had such a meeting, because here in our accounting to Parliament, there was this confusion. Unless it says our accounting to Parliament will be mediated by the department itself, and therefore we should not have an interface with any of the committees of Parliament without having to get the mandate from the department. So that is, to me, the understanding. We're working very well with the department and the ministers. We always interface with them, understanding our complementary roles. But it might as well be that this is a critical point and a crossroads on how we should be guided in the processes. Similarly, the Parliament, when they say they appoint commissioners, there is part of that protocol, the processing that takes place, including the ones of taking people for security clearance and so forth. There seem not to be clear guidance on where this is taking place. Hence, you sometimes have the delays of 2 months. And in some instances, a delay, I think I'm told, was even longer. So to me, guidance between the role players, the Parliament, the department, the Presidency, will be of great assistance. We're willing, we are able to cooperate with any of the key role players, including our portfolio committee here. But left unguided, though, we will forever have challenges. Do we do this or don't we do this? Do we do that or don't we do that? But we did point out to the committee, honorable members, and to the speaker, and to the minister and the Dpsa on the inherent contradictions for an entity that investigates sometimes grievances from departments, and the same entity through the current act and arrangement being subjected to the same departments, and hoping that you'll have unfettered independence. It's just those inherent contradictions which are in tension with the Constitution and what the framers of the Constitution intended to see. Various reports from your Kada Asmal report, Dr. Mapai's reports, the professionalization document, the NDP, are repeating exactly the same thing. So in talking about building an ethical, capable state, it is one of the things that we cannot avoid. Thanks.
Thank you, Professor. I see that Yoli Somakas's hand is up. This is the time of response. Yoli,
thank
what
you,
is
Chair.
it that you wanted to raise?
Oh, thank you, Chair. I just wanted to follow up on Professor Somadoda to say that I think it's urgent, and I want to support the view that there must be this clarification of roles and responsibilities, because he keeps on mentioning Dpsa. Dpsa only gets involved on commission issues. Now, Dpsa is a department. When there's a referral from presidency, like the appointment of the commissioners, Parliament wrote to the presidency referred to MPSA, and of course the MPSA must get the support of the department in respect to that. So our response as a department has been in support to the MPSA in respect to these roles and responsibilities. So I think it's important that that clarity is sought, so that the MPSA is also aware of his roles and responsibilities in relation to the PSA. So I'm standing to agree with the acting chair of the commission that I think it's an issue, it's an urgent issue that requires attention.
Commissioner Boshoff.
Thank you again, Chair. I just wanted to respond to the question raised by Honourable Mbele. There was indeed a lot of internal thinking that took place, Honourable Chair and Honourable Members. A lot of consultation took place, initiated by the Public Service Commission with various role players, and all the section, or rather all the Chapter 9 institutions were consulted. The Dpsa, National Treasury, even the Office of Institutions Supporting Democracy in Parliament, all those institutions were consulted when we started with the process of drafting this bill. And the product that we submitted to the minister is a product that came about as a result of independent thinking and initiatives of the Public Service Commission. In other words, we were not influenced by external institutions. We took the advice because we arranged these workshops to obtain advice to take the process further. What is important to note is that the Constitution is very clear. The Commission remains accountable to the National Assembly. There is a working relationship between the Office the Public Service Commission, Department, and Dpsa on a number of commission in our own meetings have also expressed, the desirability of us taking our matters directly to the National Assembly and directly to this portfolio committee, because we're an independent institution. However, the arrangement, and that is where the Deputy Minister is correct, the arrangement currently is that bills can only be channeled. I'm not referring to members' bills, but when it goes through the normal processes, bills can only come through cabinet, and the minister that is sponsoring the bill of the Public Service Commission is the Minister of Public Service and Administration. That is why we are going through that route. The ideal would be to take it directly to the National Assembly and to the Portfolio Committee, but currently we are not allowed. I don't think the Speaker and even yourself, Honourable Chairperson, would allow us to bring it to you directly, because that is not the process at the moment. So I hope that has assisted or answered the question of Honourable Mbele. With regards to the input of Honourable Ntuli, thank you very much, Honourable Ntuli, for the support. We really rely on the support of the Portfolio Committee to get this bill that has been on the cards for so long through Parliament eventually. Thank you very much, Chair.
Thank you very much. We all the questions that were raised are responded to now, and we must now deal with the minutes of the previous meeting. Can I invite the Secretary of the Committee to take us through those minutes?
Chairperson. Ilan Majake.
Oh, yes, Honorable Deputy Minister, you wanted to make a comment after that. Okay. I allow you to do that.
Is it okay to be excused at this point?
I allow that because you are not part of the discussions at the moment. So the departments can leave.
Thank you, Chairperson.
Yes.
Thanks, Chairperson. Thanks to you, and once again, good afternoon, honourable members.
Chairperson, sorry, Chairperson, it's Tilana Halley from Parliamentary Legal Services. May I also be excused?
I hope as we deal with these minutes, there will be no litigative matters, so you can leave.
Thank you, Chair. Thanks.
Chair, thank you, Chair. I'm not sure if you can see my projection from this side, Chair.
I can see there are minutes coming up, and those minutes are for the 16th of March.
Yes, Chairperson, thank you very much. I'll go page by page, Chairperson, and then we will then adopt the sets of minutes. We've got about 7 sets of minutes, Chairperson. I'll go swiftly. Most of them are just small, Chairperson, because we are done and the budget votes, so they are very small, Chairperson. On page 1, on the minutes of the 16th of March, Chairperson. Here, okay. Tenants registered, Chair. Then I'm on page 3, Chair. These minutes were sent 2 weeks back, and we also resent them last week, Chairperson. That's page 4.
Adopt ama-minute yami.
On page 5, Chairperson. Public Service Commission presented here on the misconduct, financial misconduct. And that's the last page, Chairperson. Thank you.
Thank you, Mastrole. Can I invite members to speak on those minutes? Or if you are happy with the minutes, there's nothing you want to correct, you can propose adoption.
Chairperson, Honorable Mbele, just very quickly, if I may.
Okay, Honorable Mbele.
Yes, just a small grammar issue on page 3. The second line under 2.3 is, I think it should say, employees who had failed to apply for pension redress within the stipulated time frame.
I'm just going to the minutes. Then you, Honorable Mbele, you say you're on page?
Page 3, and then towards the bottom, it's the paragraph 2.3.
Okay, I've got it.
On the second line, after pension redress, I think that should be apply for pension redress within the time frame, not just within.
Okay. I'm corrected on the side, Honorable Member. No, please confirm.
Chairperson, Chair. Chairman Nduli.
Honorable Nduli.
Chair. No, Chair. No, you raise the concern, Chair. So, for some of us, English, Afrikaans, and other languages are the 11th and the 10th languages. And it would be good if we correct the ones. And also, because we get the minutes, the documents prior to the meeting, if really we feel like assisting the secretary, our secretary, we for the meeting and we correct the grammar, not coming to the meeting and correct the grammar, because for me, that is the 11th language for us. But is and was, it's okay, fine.
So through you, Chair.
Honorable members, when you correct minutes, you correct the spirit of the discussions. If what is written is not capturing the spirit of the discussions in the meeting, then you can correct it.
Okay, Chairperson, my apologies. I was working from a convention from my previous committees. I'm happy to send my textual edits via email to the Secretary later on.
Okay, no, I was not in any way saying Honorable Mbele is wrong, but I was just advancing a principle of how minutes are corrected. Thank you. What is the Secretary saying?
Yes, I've made the changes, Chairperson. I'm ready now to move to another set of minutes, Chairperson.
You can move on.
Can we adopt
the
minutes?
Sorry, can't we adopt it first so that we move to the second check?
Okay, that is in order, Honorable Nduli. Can I get a proposal for the adoption of this?
I propose for the adoption of the minutes with the amendment that has been done by Honorable Mbele. Anyway.
Can I get a second to Honorable Nduli?
Chairperson, if we can just see the attendance, one is not sure whether we're part of the meeting or not. Mercy. Honorable Kibi, I let me quickly double check. However, I want to, I'll just go there now again to the attendance.
I was not part of the meeting, I can say.
No, you were there, Honorable Kibi.
You were there, Honorable Kibi.
The 16th, yes.
You were there on the 16th.
23 March. The minute.
Yes, not on this one, Honorable Kibi, but the other one you were there, Honorable Kibi.
Which minutes are we adopting, Kant?
16th March.
I second the proposal, Honorable Chair.
Thank you, Honorable Kibi. Therefore, the minutes are adopted. Can we move to the next set of minutes, Mastole?
Thank you, Chair. I was about to upload the ones of the 16th, Chair, just to show honorable members. I have minutes of the 23rd, Chair.
Chairperson.
Honorable Kondwe.
O tla intshwarela go disturb a meeting, but ke batla go tlhaloganya gore going forward, yaanong convention ya go 9, are we not allowed to correct spelling? I just want us to be clear, because I was not clear gore, you know, what you had decided on this issue.
No. You correct everything, including spelling, when you correct minutes.
Okay.
Can I continue, Chair?
Mastole.
Okay. I'm on the set of minutes on the 23rd, Chairperson. On this day, we're considering first, second term, and then third quarterly performance reports, Chair. We also adopted the minutes on the day, and we did mandate of the Public Service Commission. I'm on page 1, Chair. I'm on page 2.
Members will shout as Mastole is going on with pages if there's something they want to correct on any page.
On this set of minutes, Chairperson, there's nothing much because all the discussion are factored into the quarterly reports. I'm on page 3, Chair. That's the last page, Chairperson. That's the set of minutes of the 23rd March, Chair. Thank you.
Are there members who want to correct anything on this set of minutes?
Chairperson.
Yes, shout.
Yes, Chair, it's Manduli here.
Yes.
I rise to adopt the minutes, the set of minutes of the 23rd. But I wanted also, Chair, to clarify myself in terms of correcting the minutes. I was speaking in terms of grammar, other than spelling and the tense, if it's present tense, all those things. But I was specific on grammar.
Honorable Ndoli, you are allowed to correct. You are allowed to correct everything, including grammar and everything, because the minutes after this, they become the record of the meeting. So we must not have a record of the meeting that has wrong things in it. You can correct.
Indeed, Chairperson, you are quite correct, Chair. The secretary sends us the sets of the meeting prior the meeting. So in terms of grammar, maybe in my old school, when I was doing secretariat, those are the things that were picked up. There are things that you can't just do in the meeting. But it's good because you are part of the meeting. Even if it's the chairperson of the secretary of the meeting, if you are phoning him, and trying to communicate with him. It's not an offense. It's not an offense. But coming to the meeting and say, only if the minutes are capturing the sense as to what was said in the meeting.
Okay, I see Honorable Malomane.
Thank you, Honorable Chair, and greetings to everyone. I second Umamdul.
Thanks, Chair. I will continue. I am on the sets of the minutes of 3rd May, Chairperson. Once again, here, Chairperson, we were briefed on budgets, Chairperson. I'm on page 1. We were dealing with DPME and family. Page 1, page 2, page 3, attendance. Then page 4, page 5, page 6. Once again, Chair, the discussions on these minutes are factored onto the reports. There will not be much information on these sets. However, the discussion, intensive discussion on the reports. Thank you so much, Chairperson. Those are the minutes of 3rd of May, Chair. Thank you.
Thank you. Can I get a proposal for the adoption of this set?
Thank you, Chair. Mkweba.
Yes, Honorable Mkweba.
I'm moving for the adoption of the minutes of the 3rd May, Chair.
Thank you, Honorable Mkweba. Any seconder to Honorable Mkweba?
Honorable Duli, I second.
Honorable Duli, Honorable Kibi are seconding. Therefore, the minutes are adopted. Can we move to the other set if there's any?
We are on the set of 6 May, Chair. On this day, we were just purely considering the 5 draft reports, Chair. I'm on page 1. On page 2, the reports were adopted on this day, Chair. And then page 3, that's the last page, Chairperson. Thank you.
Thank you. Can I get any member to propose adoption of this set? I see Duli and Honorable Maloman. Honorable Duli?
Yes, Chair. I rise for the adoption of the minutes, Chair.
Malomane?
I second, Chair.
Therefore, the minutes are adopted. Is there any other? Look, Mascol?
Yes, Chairperson. We're almost there, Chairperson. We left with 2. On 18 May 2022, we're briefed by stats on census and also TPME on the NTP. We also considered the report, Chairperson, of the oversight. Sorry. I'm on page 1, which is attendance, and page 2, page 3.
Members will shout if there's anything they want to change on the pages as they move on.
And page 4. I'm on page 5. That's the last page, Chairperson, page 6. Thank you.
Honorable Nduli, I give you the platform.
Thank you, Chairperson. I rise for the adoption of the minutes, Chair.
There's a proposal for the adoption. Any seconder to Honorable Ntuli?
I second Honorable Chair Skibi.
Thank you. That set is also adopted by the meeting.
I am on the second last set of minutes, Chairperson. The minutes of the 25th of May, where we dealt with the medical aid scheme. Page 1, Chair. Page 2. Page 3. Page 4. That's the last page, Chairperson. Thank you.
Honorable Ntuli, I see your hand is up.
Thank you, Chair. I adopt this set of minutes, Chairperson.
Adopting and Honorable Malomane.
I'm seconding, Honorable Chair.
Thank you, Honorable Malomane. The minutes are therefore adopted by the meeting.
Okay, Chair. This is last week's minutes, Chairperson. The minutes of the 1st of June, 2022. It's the last set, Chair. I'm on page 1. And page 2, Chairperson. Page 3. Page 4. Page 5, the last page, Chair. Thank you so much.
Thank you, Mascole. I see Honorable Ntuli and Honorable Malomane. Honorable Ntuli, take the floor.
Thank you, Chairperson. I propose for the adoption of the minutes. Thank you.
Thank you, Chair. Those are the last minutes.
Thank you, Chair. I second.
Therefore, the minutes are adopted with the secondment from Honorable Malomane. Was that the last set, Mascole?
Yes, Chair. Thank you.
Thank you very much, honorable members. As I said, this is the last minute meeting of this term. We will meet again now in the second term. The meeting now stands adjourned. Thank you very much.
Thank you, Chairperson.
Thank you, Chairperson. It's very cold in KZN these days. Hey.
Thank you, Chairperson.
Thank you.